What's up? We're back at it here. Nighttime discussions about a trial that's going on today and for the next, I believe, 2 weeks. I believe this trial is set to go for 8 days, the Gwyneth Paltrow ski accident trial. We did a little intro video yesterday, and we talked about how there's a ton we don't know about this case, and we're going to let it come out during this case. But I did talk about some overarching themes I would expect just based off the causes of action that were discussed and the actions that were explained by each side with the he said, she said stories, two opposite descriptions of one event, which is not all that uncommon. And this, folks, is why we have the court system, why we have judges and juries and people to decide who is telling the truth, who is lying, who is correct, who is not, so we can settle disputes in a cordial and civil manner, hence the civil justice system, and this being civil court. I see a lot of people saying that this case is a waste of the court's time. Well, if you felt like you had a brain injury and broken ribs because of somebody else's actions, or if you felt like you were sued wrongfully and it was a frivolous lawsuit trying to besmirch your name, I think you would appreciate having a forum to air that out and get a final answer. And that's what this is for. So we're going to talk about it. There was some interesting fireworks, some interesting lawyering. I got a lot of comments on Twitter and Instagram about the lawyering. So we'll talk about that. We'll talk about some of the procedural things going on. We'll talk about some of the stuff that I just think it's wild they're talking about this in front of a jury, because in most of my cases, we wouldn't be allowed to talk about some of this stuff, but it is a different jurisdiction in Utah. So we're going to talk about all that and more. And of course, as always, I am going to answer your questions like we always do. So hit that like button if you guys haven't already. And if you're new to this channel, where we give a recap, we break down, we give some legal analysis, and then we do a lot of Q&A to discuss what you, potential members of the jury, the chat, whatever we're calling ourselves these days, what you think about this case and what you think about these proceedings and these witnesses and these lawyers, because it also helps me. I'm a trial lawyer in Florida, and it helps me understand how potential jurors would look at arguments like this. Injury cases is what I do. These are the kinds of trials I have. I've never tried a ski crash case, but it's basically a car crash case without the cars. So hit that like button, subscribe to our page, and let me know if you are new to this channel from the Paltrow case by saying Paltrow in the chat. So before the opening statement started, before any witnesses were called, we hear about 8 jurors plus 2 alternates that were picked. They only need a 3/4 majority to make that decision. So 6 out of the 8 jurors need to agree on who is more likely right than wrong, the greater weight of the evidence, and how much money to give that person, if any. We heard about one of the plaintiff's experts, Dr. Fong, and how the defense challenged her testimony, and the judge felt like she did not pass the muster that is necessary in the state when they talk about peer review and how reliable her testimony would be based on the results that she got from other tests. She can talk about what those tests are or what scans show, but not necessarily her system and where she gets her opinion, which is a big blow to a plaintiff in the beginning of the case. You never want to get your expert witness testimony limited. We heard about some media violations. People already taking pictures of Gwyneth Paltrow in the lobby. The judge had to scold them and remind them that there are only certain feeds and certain people that can take pictures. And if you want to tweet during the trial, you've got to get court approval. And he's going to ask the attorneys before he allows anything like that. If you leave the courtroom, you have to wait till a break to come back. Some very strict rules on the gallery and the media, not as strict rules with the lawyers. And we'll talk about that in a little bit. The schedule will basically be 9 to 5 every day is what he said. And he said in front of the jury that there was a claim against Deer Valley Resort, and the court dismissed that claim. If I was the plaintiff in this case, I would not have wanted that to come to the jury. I would wonder what the relevance is of that. And if the jury thinks Deer Valley did something wrong, they can think Deer Valley did something wrong. If they want to think that Deer Valley is not credible because they're biased towards Gwyneth Paltrow, they should be able to think that. But that wasn't the only time we heard about these claims against Deer Valley being dismissed by the court. And we've talked in other cases. Jurors usually love the judge. They trust the judge. So if the judge threw out a claim, they're going to think that claim was bogus. And if you've already gotten some claims thrown out as the plaintiff, you're not starting out in a great position. So first we get to the plaintiff, Mr. Sanderson, his opening statement. We're going to talk about the lawyering. You guys know I like to be as respectful and nice to lawyers as possible. I will just say I think these two opening statements were not... Somebody asked the other day, do they teach you in law school how to be an eloquent speaker, how to be a good public speaker? Do they teach you charisma? Do they teach you how to be engaging? And I said the answer to that is emphatically no. They teach you trial practice. A lot of that has to do with procedure. And I would say that these were not two of the most charismatic and engaging lawyers. They may be very good lawyers. They seem very smart, but they were not the most engaging to me. I could be wrong. I mean, I shouldn't say I could be wrong. That's my opinion. You could have a different opinion. And so it was a very awkward start with the mics and turning the podiums and being married to the podium. I would say at one point, like, Judge, I put this lavalier mic on. I've got the mic packets turned on. If it doesn't work for the cameras, so be it. I'm walking around the courtroom and talking to this jury like a normal group of people. I'm leveling with them. I am not going to be married to this podium. I'm not going to lean over and make sure I'm into this mic that's attached to this podium unless the court orders me to, which I don't think they would, because the jury could hear him, and that's what matters. But he didn't do that. Instead, he literally repeated a written down line multiple times to start his opening statement. Distracted skiers cause crashes. I'll have a couple references to law school throughout this trial, but having some canned start like that reminds me of law school. And he said it like 3 times because he had to keep starting over because of the mics. He focuses in on duty. What is the duty that skiers have on a mountain, which I think is important because we know this is a negligence case. It's just like a car accident case. Duty, breach, causation, damages. We broke them down in detail in our intro video if you want to check that out. But we hear about Gwyneth Paltrow and how you need to be careful. You need to know the rules. Because if you're a distracted skier, it's not a matter of if, but a matter of when. And Paltrow was skiing with 9 different people. Makes her sound like a big celebrity. She's got her whole crew with her. Her kids, her boyfriend, multiple ski instructors that are basically her paid people is what he made it sound like. And he absolutely paints the picture of Deer Valley of being biased toward Gwyneth Paltrow. I think it's fine. I think that's going to be an angle of the case and an argument in theory by the plaintiff. Then he talks about this like meetup group that Terry Sanderson, the plaintiff, was part of that I thought sounded weirder than the group of 9 people skiing together, where you like post online and you meet up and show up and you don't really know each other because Mr. Ramon, who's going to be the first witness and who's the eyewitness to the crash, like they know each other, but they're absolutely not friends. They're not close, nothing like that, which, you know, he's trying to shy away from bias. I usually don't shy away from bias when I call witnesses, before and after witnesses, whatever. If it's a family member, a girlfriend, a friend, whatever, it's like, sure, they're friends. Does that mean they're going to come lie under oath and commit perjury? No. But these are their friends. Why does that make what they're saying not truthful? I think lawyers get a little too scared of bias sometimes. And when we get to that witness, I'm going to ask you guys, if you felt like if you would have just said, yeah, we're friends, would that have made him more believable or less believable based on the fact that they're trying to really prove that they're not friends? But more on that later. So they get to the meetup group. He's skiing, Paltrow skiing, and then we get from the lawyer's own mouth of the plaintiff the description of what he believes happened based on his memory and the only eyewitness, which is Mr. Ramon, not Mr. Sanderson's friend. So let's get to their description of how this ski accident happened.
Before they ski, one of Ms. Paltrow's children says,
and this is on 1.5 speed, and I'm not even apologizing to anybody that is frustrated with me playing it on fast speed. The only way, but we're going to listen to it on 1.5 speed just to compromise. I'm a man of compromise. It's what I like to do. So this is Stephanie Sanderson's attorney, the plaintiff's attorney against Paltrow. The first opening statement, plaintiff's opening statement.
Mommy, watch us ski. Okay.
So he said, one of Paltrow's kids said, Mommy, watch us ski. That's the distracted skier. Now that's what distracts her.
The children and their two instructors ski to the left. The two instructors are Eric Christensen and Carrie Oakes. Miss Paltrow skis down to the right. She turns her head up to look at her children. As she turns her head back down, she screams. Then skis back into the back of Terry Sanderson. She rises back down. They hit the ground hard, and Miss Paltrow bounces off of Terry. The weight of both of them, their bodies, caused Mr. Sanderson's rib cage and his arm to smash into the ground, breaking 4 of his ribs.
You know this is a pet peeve of mine, because a lot of you disagreed with me when I said it's about some attorneys you loved. But I really don't like when an attorney reads the entire opening statement. I don't mind having notes. I don't mind having an outline. I don't mind referencing some notes and then looking back up and engaging with the jury. You should know this case enough to just, like, he needs to look at his notes to explain how the crash happened. If he needs to look at like a specific medical record or a specific statement somebody made, but you can't explain to this jury this case you've had for years as to how the crash happened. I feel like I'd be able to really engage and try to make them feel it, not look down at a book and read it. You know, I don't love that disengagement with the jury and with the audience, your audience.
2 of them completely. Sanderson's helmeted head hits the ground, causing a concussion as his brain strikes the inside of his skull.
And then he answered another question that you all had. One of your big questions. You had a couple big questions in our intro video. Was he wearing a helmet? Because we knew he had a concussion or a brain injury. So he says, Sanderson's helmeted head. If you think that's not intentional, you're wrong. Give yourself more credit. Exactly what you all think. They probably focus group this and people were like, was he wearing a helmet? They probably immediately asked that. So they knew that that was going to be a question the jury had. And so he make sure to say his helmeted head, and his brain rattles around and hits his skull.
Sanderson is face down in the snow, unconscious. Skiing 35 feet above them, Craig Ramon is the only eyewitness to of the crash. Ramon skis down and stops just next to them. He asks if they are okay. They say nothing. Ramon, again, is the only witness of this crash. Miss Paltrow is slow to get up. Her son's instructor, Eric Christensen, skis over from the left and stops above Sanderson and screams at Sanderson, who is not moving. What did you do? What did you do? Surprised by the crash and Christensen yelling at Sanderson, Ramon thinks, why is this Deer Valley guy screaming at Sanderson? He didn't cause this collision. Christensen doesn't let up, so Ramon steps between them. Christensen stops yelling at Sanderson. Sanderson is still not moving. They ask Sanderson if he is okay, but Sanderson only groans. Craig Ramon turns to Paltrow. Are you okay? He asks several times. Are you okay? She doesn't say a word, and she slides a few feet down the hill. Terry moves a little and groans. My ribs. Paltrow turns away and bolts down the mountain to the bottom. Christensen turns to Ramon. Do you realize your buddy just took out Gwyneth Paltrow?
So, do you realize your buddy just took out Gwyneth Paltrow? There's some discussion around that statement later. But what's really interesting is how immediately her celebrity becomes part of this case. And to me, was the most interesting and eye-opening part that potentially will sink the plaintiff's case is how they all reacted, he and his witnesses, to Gwyneth Paltrow being part of this case.
Sanderson moves more, trying to get his skis around. Eric Christensen steps closer to Sanderson, picks him up by his hands, and stands him up. Snow is caked in Sanderson's goggles. Christensen turns his skis down the mountain, and he bolts, skiing straight to the bottom, following Paltrow's group, leaving Sanderson and Ramon alone at the crash site. Sanderson is standing but hunched over, mumbling. And Ramon says, do you think you can ski? I think so. Sanderson tries, but skis poorly. Ramon says, stop, you forgot how to ski. Do you know your name? Terry. Do you know where you are? I have no clue.
He's trying to give an opening statement that really connects and grabs people, like this is a serious brain injury, forgets where he is, but he just doesn't have those facts. He may have a concussion. He very well may have a concussion, But sometimes if you overreach as a plaintiff and you talk about this brain injury, as we talked about in the intro, what do you expect? What's a jury going to expect when you say brain injury? And if you respect your jurors as a lawyer and you don't try to pull one over on them, or you don't try to overreach or exaggerate your client's injuries, 4 broken ribs is incredibly painful and very believable to happen in a ski crash. A concussion is also very believable. You hit your head. But to push for brain injury, debilitating for the rest of his life, he's not able to do this, that, or the other, you've got to prove that then. And getting up and skiing immediately and remembering your name, and he says he goes to Instacare, not the emergency room, those are some of the things that then make a jury say, So you've got to be honest with your jurors, and you've got to respect your jurors, I think.
Ramon says, let me get some help. And Ramon steps back and flags down a Deer Valley employee and says, can you get ski patrol here? This guy's been hit. He's hurt, and he's just out of it, disoriented. Within minutes, a Deer Valley ski patroller, Whitney Smith, arrives with a sled. Smith examines Sanderson, puts him in a sled, and takes him down to the first aid station at the bottom of Bandana. At the first aid station, Sanderson again is evaluated, and he still has some disorientation. His ribs hurt. Whitney Smith tells him, and the group of people in the meetup group that are with him, he needs to go to an Instacare in Park City. Terry goes to the Instacare with someone who drives him. He's not sure who it was.
So then I also have this question, because I always think about this. So Stephanie said, a concussion is a brain injury. 100%. I agree with you. But I think the way that you explain it and the way that you explain the effect on somebody's life can legitimize it or illegitimize it. That's all I'm saying. Because there are differing variations of brain injuries. I think we can all agree on that. So this is something lawyers always lose sleep over. Do you guys find a big difference between going to an urgent care or an Instacare versus an emergency room? And I see somebody saying, did he go by ambulance? So he didn't go by ambulance. So do you guys see a differentiation? We usually do when we look at certain cases and use like immediate ambulance to the emergency room versus going to the Instacare or the urgent care. Usually people see a difference from that. I don't know that there is one, but I want to see what you guys think.
And at the Instacare, he's evaluated, but the Instacare says you need to go to an ER room. It appeared that his pain in his ribs might be broken, and he reported that he was unconscious. The next day, Terry goes into the VA emergency room. So what does the defense have to say about these things? First, they say, that's not the way this happened. He hit.
So people are saying not a big difference. People say, I have a preference, but it depends. Okay, cool. That's good. I agree with you, I think. Okay, so now he's going to go into what the defense is going to argue happened. So we don't have to listen to all the defense's explanation, but this is generally, he's being a little bit sarcastic, I think, or a little bit saying like, this is impossible. It couldn't have happened like this, but still an explanation of some of what the defense is going to argue. Just about 2 minutes of this.
Me from behind. I know the witness Ramon says he heard me scream and look up and saw the crash. I never saw Sanderson before he hit me. Sanderson was the one who hit me. This wasn't my fault. They also say, the defense, this is all Sanderson's fault. He's the one who can't remember the crash. My ski instructor, Eric Christensen, said he saw Sanderson above me making big turns and going really fast. This is Sanderson's fault. And they say, look, what's the big deal? He's 69 years old. Our doctors say he had some dementia and blindness in an eye and many other problems. Yeah, he broke some ribs, but those will heal. And 85% of people with brain injuries heal.
So he's being sarcastic, but I think he's making some of their arguments for him. And this is the old, Eminem 8 Mile trick where you try to say, I know everything you're going to say against me, and you try to beat him to the punch. But I don't really know how effective it was, in the way that he's explaining it.
Big deal. Oh, and look at his high test scores. He can't have a brain injury. And finally they say, so what if he had a head injury and 4 broken ribs on the day of the crash? 8 hours later, he wrote to his daughter, I'm famous. That shows he can't be injured. And this is just about celebrity of Miss Paltrow.
So that's the basic gist of what each side is saying. And we'll have more clips here in a little bit. He also explains that his expert's going to say, because he has the effects of this brain injury after 18 months, it's a permanent injury. And technically, under the definition, it would be considered a permanent injury. Do you all have an issue with that? Or would you like to see the level at which the issues continue? What is that? How do these cognitive issues continue to make it a permanent injury? He talks more about the ribs, the concussion. He was an eye doctor in the Army. That usually has good jury appeal. He would be seen as, I'll just tell you, I have a lot of clients that get injured and have cases like this. He would be seen as an A+ client. Eye doctor from the Army, retired. That's as good of a client can be on paper. Now, what his actual personality is like and what he talks about and how people like him, who the heck knows? But just as a starting point, that's about as good as you can get. He does, and they admit he has a prior brain scan. NPH, he talked about what that was. I'm already forgetting. Some of you guys can remind me what that is. But no prior symptoms, they say. So why did he get a brain scan if he had no symptoms? I always think that's interesting. But the plaintiff doctors say absolutely has nothing to do with this. All of his issues that he is, yes, he went to the VA because he is former military, retired military. So they talk about the BNA witnesses and before and after witnesses we have in just about every injury case. They are able to explain what the plaintiff was like before the accident and what they were like after, because part of the civil justice system is to help get the plaintiff as close to the pre-accident form as you can. And while that's impossible, money damages are the only thing we have to help us with that, with treatment, with therapy, whatever that may be. We heard that the media was wrong. Deer Valley did not see the crash. There was an objection. The judge told him he can't talk about media discussion. There was very few objections during this opening. The next one a little bit different. And Sue asked, which I knew I had this coming, Sue, so I was saving your question. Why was Sanderson out of the courtroom for the majority of the day? He said in his opening that Sanderson, it just hurts too much to listen to. And the lawyer said, we don't want to rub his nose in it. So he's not going to be in the courtroom for parts of this case. This opening, when some of these before and after witnesses testify to just how different he is and how he's not the man he used to be or was before this crash. So he will not be in the courtroom for some of this. And it leads me to a question for you and for the chat. What do you think about that? If the plaintiff is not, because some lawyers, this is legitimate, some plaintiffs just can't listen to it, can't bear to listen to it. Some courtrooms will force the plaintiff to stay in there as a party, or the defendant can object to them leaving. But then you kind of look like a jerk. Some lawyers will use this just as a ploy and as a jury tactic, and so that the jury will feel more bad for him, like he can't even listen to this stuff. And like I said, sometimes it's legit. What do you think? How would this affect you if the plaintiff left the courtroom for certain portions of testimony that were just too hard to listen to, like somebody explaining how he changed? So people are saying grandstanding, playing the gimmick, feels odd. I think it would look bad, drama play. So nobody really likes it. And here's one of the issues. So we've never done this. I'm not saying I never would. We would have done it in a couple cases where we have deceased children and their guardian or parent is the person that sits at counsel table. We would have done it in a couple of those cases, but they settled. But if a person is bringing a claim, usually we talk to them about how difficult this is going to be. And part of the process is sitting there and facing this process. But again, this is why people don't usually like their issues and their dirty laundry aired out here on court TV, right? And that's the point. And that's what I tell you about a lot of my cases is they don't want you to know that they had, prior issues or prior brain scans or an estranged daughter that's going to come testify against them that we heard about, right? Those are family issues. That's family business, like Kanye West said. This is family business. So a lot of this, Fran thinks it's a BS tactic play. And sus, that's one of our favorite words here for today. So yeah, a lot of people are kind of feeling that way. And then they say they're going to ask for $3.2 million in damages. We heard the 3.1 number. We heard then they said damages to be considered a trial. Who the heck knows how they're going to get there? We will find out. Past medical bills, future medical bills, past pain and suffering, future pain and suffering, probably not a lost wage or lost capacity to earn because he in fact does have, or he is retired. Also, they said he's former military and in the VA. So we know he has those VA benefits. Will the jury limit the award because of VA benefits? They're not supposed to, but that's always something we think about when we talk about the VA or whatever, because he may not have the VA benefits forever. It's kind of another discussion for another day. But let's get to the defense's opening. He talks a bunch about the justice system and about Lady Justice. He talks about how you can't feel sorry for Terry. And he gets to, and this just makes me happy, right? The issues we talked about are exactly what he's hitting on. What are the overarching themes we talked about? Inherent risk, waivers, right of way, he said, she said, failure to render aid. Those were the overarching issues, and he hit those. He even testified a little bit, and with all the objections flying around, I don't know if you guys noticed, if you've been watching enough cases, and you know that usually the lawyer that does the opening is the one that has to object when the other person's doing the opening. It's kind of like a mano y mano or womano y womano. But it wasn't. The lead lawyer, the more fiery lawyer as it seemed, started objecting and just kind of didn't stop. But he didn't object to him testifying that we've all been, well, Michael Wagner. So let me just correct you, and how, at least how Florida courts see it. Nothing is 100% for life. The government can and has changed things that they said they never would. And I'll just leave it at that. When we're talking about future bills. But anyways, where was I? I just lost it with that comment. Oh, inherent risk. And he talked about, I've been hit. You guys have probably been hit. Everybody's been hit when they're skiing on a mountain. And he says, listen, we believe this claim to be utter BS. And that's where the objection started. That one was sustained, as many of them were. But we may have a count as to how many were overruled. He's a little all over the place, this lawyer, I think. He made some really good points, but then he kind of loses the audience, I think, with some of his presentation. And of course, Gwyneth Paltrow is a conservative skier who always wears her helmet and always pays attention and always rides on the right side of the hill that she's supposed to and always weaves back and forth. Whatever. Okay, that's how lawyers are going to portray their clients that are defendants in these situations. Of course, she was a cautious driver. She always uses her blinker. She always stops at stop signs. That's how they all explain them in these kinds of cases. But I did think it made sense as he was explaining it to show that this was not a high velocity crash. They were not going very fast when they hit each other. He also talks about how Mr. Sanderson had medical issues before, and the pre-existing conditions that he had, and that this crash did not cause a lot of the brain injury. We didn't hear him talk a lot about that it didn't cause the broken ribs, and that's what I'm talking about. If you have the issues that are difficult for the other side to combat, like concussion and broken ribs, it's hard to argue against that, and even a low-impact ski accident like this, because you hit the ground. And when you hit the ground, things happen, and your brain can shake. But when you portray it to a certain level, that's when it gets more difficult. So then Paltrow's attorney takes the opportunity to remind us of something that the judge said.
He's there. So upon Gwyneth, he back turns with his better eye, and suddenly she's there.
By the way, his better eye was a total little jab at, he had these problems before the crash. One of his eyes was bad, because there are some records that say that.
The Deer Valley report, do you mind? By the way, Deer Valley is not a party to this lawsuit. The court dismissed Deer Valley. So Gwyneth's not Deer Valley. Deer Valley stands on its own.
Objection, argument, Your Honor. Overruled.
Objection overruled. So these are some of the things I said. Once a party gets dismissed of a lawsuit, usually that's not relevant to this lawsuit against Gwyneth Paltrow. Because Gwyneth Paltrow on her own was negligent. And Deer Valley, whether or not they were negligent, does not necessarily affect Gwyneth Paltrow's negligence. So usually we limine this argument out. But the judge said it, the lawyer reiterates it, so the jury knows The plaintiff has filed claims against Deer Valley, and the judge, the good guy we all think is fair and impartial, dismissed them.
Deer Valley stands on its own, and I don't know if they're going to assert like there's some massive cover-up or what, but
Objection. Argument. Sustained.
So he sustained that one, and this is where knowledge outside of this courtroom comes in, because we know there was cover-up causes of actions, conspiracy-type causes of action that went away. We're going to talk about hit and run in a little bit, but he knows that that exists, and that's an argument he's kind of scared of, and he wants to come out. I shouldn't say scared of. That's an argument he wants to combat. He wants to combat the Deer Valley liability. He wants to combat the hit and run. It's very clear. Lawyers show their hands when they have the opportunity to make opening statements and closing arguments.
okay, back one, I think, James. By the way, I think the goal is to give everyone a little better access with these little screens, but it hasn't worked out today. So Eric Christiansen, remember, he hears and he turns and he goes directly over there. He's there within seconds, and he's seen what happened. And what does he say? Can you blow up the first half? Chief complaint, male skier took her out from behind.
So this is Christensen, or however they're saying his name, works for Deer Valley, was the ski instructor for Paltrow and her family, who was right there when it happened, but there's some argument about whether or not he actually saw the crash, and he makes a report. Now we're going to hear about when and how these reports are made. He probably is going to say he made this report based on what he saw and who he talked to. And we're going to hear exactly what Sanderson said to him. It's an exception to hearsay because it's the party opponent. So if Sanderson said, I ran into Paltrow, and that's what Christensen's going to testify to, that's going to be pretty big evidence for Gwyneth Paltrow. So let's hear what's in this report and what I assume he's going to testify to later. Now, sometimes a report won't come in as hearsay, but it is coming in this case. Usually, when I have situations with reports, a lot of times the person would have to testify to it. The report wouldn't be able to come in.
He's putting this together, and then let's do the bottom thing, and then we won't focus on exhibits anymore really today on this. But first thing male skier said, does that say said? I can't read it. Anyone?
Stated.
I've also never seen a lawyer do stuff like this. What does that say? Anyone? Like, who's he talking to? The jury? I mean, I guess he's talking to his team of lawyers, but his team of lawyers, like, it says stated, boss. It says stated. But he does it here, and then later he says something else where he asks about a date, or he asks about, one of the kids' names or something like that. And it's like he's just like asking people for help while he's giving his opening statement and questioning witnesses, which I thought was an interesting style.
Was that she appeared right in front of him, thus admitting that he was the uphill skier. She never saw him because he came in from behind. That was the evaluation from the Deer Valley skier, from the Deer Valley instructor.
So, as we already knew, Deer Valley in lockstep with Gwyneth Paltrow's version of the story. That is a contemporaneous report in 2016. That's tough. I'll just tell you, as a plaintiff's lawyer, if this report existed and this is how Deer Valley put everything together, you'd almost have to claim that there's some kind of cover-up or bias or that they're working together, because that is tough. That is tough to overcome. And then, as we mentioned, they want to make sure we all know this is not a hit and run. Let's hear him explain that. And if you listened before, they made this argument. The judge, the defense lawyer, this guy, made an objection saying, Judge, they should not be able to say it's a hit and run. He should not be able to say an opening statement that Gwyneth Paltrow bolted. And the plaintiff's lawyer said, Judge, I'm just repeating testimony. That's what Mr. Ramon is going to say, that she bolted. And so he makes sure the judge overruled that objection and allowed the plaintiff's lawyer to say that. So the defense lawyer is going to make sure that he hammers home, this is not a hit and run. You will not hear anybody argue it's a hit and run. And I actually thought this was effective, and you have to do it if the judge is going to allow any gray area or any blurred lines on something that could be damning for you. Because if the jury, a lot of times we focus on the actions of the parties, like we say, many times, the jury picks the party they believe, the party they think they did what's right, and against the party they think did what was wrong. So if you start to bring in the fact that you hit and ran, that's a lot worse of an action than just an accident, or they maybe even mutual crashing into each other or whatever, is a lot different on how you look at that defendant, rather than if they hit them, saw them groaning or knocked out on the ground and ran and tried to escape liability.
Patrol person who's different than the instructor. A ski patrol person came by and said, everyone okay? And he said, Mr. Sanderson and Craig Ramon, who you're going to meet this afternoon, talked to each other and said, we're okay. And they said, we're okay, and the ski patrol left. All right, now everyone's okay. And then I think Eric Christiansen, okay, Gwyneth, you can go join your family. By the way, your family's waiting for her at the bottom. Brad, interestingly, had heard it and looked up and saw his wife on the ground and had come back up, and she had skied down to be with him, not to leave. By the way, you'll never hear the words hit and run in this whole trial. This was not a hit and run. The plaintiffs even had a ski expert evaluate it, and they said it's not a hit and run.
So my guess would be that those facts are not coming into evidence. I don't think the plaintiff's going to call that ski expert. Maybe they are, but he, again, just brought in things that I think happened that he knows about that we don't know about. That sounds a little like the Murdoch case with the blood spatter expert, but they had a ski expert look at it and he said it's not a hit and run. That's pretty big evidence for the defense, I think, in this case.
So take that out of your mind. All right. So, all right. Now what's going on? Okay, everyone's good to go. Everyone went. Terry, right before he left, apparently, Eric Christiansen said, your buddy just took out Gwyneth Paltrow. No one knew who she was.
And that is when the celebrity became part of the case. So then we hear how they're going to say that Sanderson was out cold for 2 minutes. Yet earlier they said he was groaning. 2 minutes is a long time for all this stuff happening, and Christensen arriving on scene and Ramon being there. All that seemed to happen way sooner than 2 minutes. Yet there's some testimony that he was out cold for 2 minutes. Again, exaggerating potentially. You don't want to do that. Somebody out cold for 2 minutes is a long time versus days. They're out for a few seconds. Then he makes a mention that, and he calls Sanderson a name. It's a dirty name. It's a name that has a lot of baggage that comes with it. And that is that Sanderson is a poster. A poster when it comes to social media. So we know that they are going to have social media posts, emails, whatever, that they are going to use against Sanderson. Because what do we always say? Using someone's own words and actions against them is the best way to defeat them. And then we get, we're not there yet. We're not to the post yet, because then he also says, we're going to talk a lot about medical records, how he had some pre-existing conditions. I know we have a nurse on the panel. So there is a nurse that is part of this jury. And you all in this chat, I know we have a lot of nurses and medical professionals in this chat. And it's really fun to discuss things with you. But I will tell you, there are some cases where I really want nurses on the case. There are others that I don't. And there are different reasons for that. Because I don't want jurors sometimes to dig into the weeds and see a medication that really has nothing to do with the case, but because they know certain things about the medication, they may make it part of the case when it shouldn't be. But then there are other times where I want a nurse to explain, this is a really hard recovery. Knee replacement and the rehab you have to do under that is excruciatingly painful. Hip replacement, whatever. So it all depends on the case. And he mentions that there is a nurse on the panel. I just thought that was interesting. And we know as lawyers, we keep track who's on the panel. Who are we talking to? Who's our audience? Really important as a trial lawyer. But then we get to the most shocking evidence to me of the day, and potentially most damning, is how the celebrity enters this trial, literally in this case, immediately, as he makes the quote we knew was coming, I'm famous. But I didn't know the context. We start to get a little context here.
On his 6-year-old CT of the brain. It's kind of crazy. They're interviewing him. He's telling them things, but no one's actually trying to go back and sort of say, look, is his brain different? Okay. You're going to hear from some daughters. By the way, there was reference to 2 daughters. He has 3 daughters.
It's the other thing. You did the Eminem. You did the, I know everything you're going to say about me. It's like, oh, no. You mentioned 2 daughters who are going to come testify, but he has 3. Why didn't they mention the 3rd one? Defense lawyers love this. You tell me, because he's going to even like kind of semi-apologize for, listen, we're doing our job. We've got to pick this guy apart. We've got to treat him like a criminal defendant. He doesn't say that, But that's sometimes how they treat plaintiffs in these cases. They dig up the dirty laundry and they put it out in front of the jury. Does that make you dislike this guy, or does that make you think, oh, wow, maybe the plaintiff is a scumbag? Maybe we do need to know the dirty laundry of this plaintiff. Because I think some jurors, I had a lot of comments about this guy and this lawyer. Some people liked him. Some people thought he did a good job. Some people thought he was like blubbering. Some people thought he was so hard to follow. But the most common comment I got about him was that he was a condescending jerk. And I don't know if it came from this, probably mostly came from when he discussed the witness. I thought he made some really good points, but his style is absolutely a certain way. But I also have some feelings about how that witness was, but we'll save him. We're going to get there.
He's on the outs with that daughter. She paints a not that great story about him before the ski accident. Why do we dig into this? No one wants to dig into this. But if a 75-year-old man says, I don't think as well as I used to, my brain doesn't work as well as I used to, I forget things. We have to, which is why we're all here, we have to go back and look at these things. If he says my relationships were harmed by Gwyneth, we have to go back, it's kind of a deep dive, and say, what were your relationships like before this? And it's not pleasant. I mean, like half of the trial is going to be on this kind of stuff, because if someone says, I have a severe $3 million brain injury caused by you, we have no, I have a lawyer obligation to represent my client and say, what's true? And I'm telling you, he does have confusion. He does have strained relationships. He does forget some things. But guess what? It's a normal aging and his pre-existing problems coming forward and progressing. Back to the story. So Instacare, they say, go get a CT tomorrow. And then he posts, and let's put that up. So he's a poster, okay? Big on Facebook. So there are lots of pictures of him, which helps us. It helps us understand him. What does he post?
It helps us. He means it helps the defense, because they're going to talk about all the trips he took around the world when he was, his life was ruined, potentially, is what they're arguing.
To his daughters. I'm famous. He doesn't post, I'm hurt. He doesn't post googly gawk. Is that the right word? Confusing stuff.
Googly gook.
Could you highlight the bottom half?
But hey, can't blame a guy for missing a one-liner.
I'm famous. This is at 8 p.m. The accident had occurred just before lunch. So
11:55 was the time on the incident report. So 8 hours later, he types to his daughter, I'm famous. No, I broke my ribs or have a brain injury. No, I can't think straight. Again, the party's own words and actions.
8 hours later, he's home. And then he said, here's what happened from my friend and eyewitness.
So he said, here's what happened from my friend and eyewitness, and there's a link, and we're going to talk about this link. But when Mr. Ramon was on the stand, he said, any other friends around? No. And we heard plaintiff's counsel say, you were the only eyewitness, right? Right. Was this video from you? No. Did you have a GoPro? No. So then who the heck is he talking about here? Who's his friend and eyewitness? And is he bragging about having an eyewitness? That was his friend. And it's his friend, not just some guy he skied with from a meetup group. A lot can be taken and picked apart from a good lawyer with a post like this.
Craig, and he posts it. He posts it. Wouldn't you be interested to know what this post was in real time? This video or photo? It's apparently video.
Objection argument.
Your Honor, that's just trying to explain the evidence here.
So you've got evidence. This is evidence that will come in.
That it's not there.
Okay. Overruled as to that.
Wouldn't we all like to know? I apologize. We're okay?
Yes.
Wouldn't we like to know what this was?
Objection argument, Your Honor. Sustained.
Yeah, exactly. He immediately got an overruled objection, but then he argued, wouldn't we all like to know what this was? But point got across to the jury. We don't have that video. We don't have whatever was in that link. We don't have the GoPro video. Wouldn't we like to know what he was referencing, that he's famous? It's interesting, I think.
It's nowhere to be found. We're in a courtroom 7 years later trying to figure out what happened. It was right there. Nowhere to be found. And
he also, so that's called a negative inference there, because the plaintiff never produced that video. And he mentions the 7 years later, which a lot of you have a problem with how long this took. Now, much of that can be due to COVID and due to our judicial system being clogged and things like that. But Maybe it seems like he also waited quite a while to file the lawsuit, but it's neither here nor there. Then he pulls out a dollar bill. He talks about, I was wondering if he was going to say, oh, she's going to give this money to charity, but he doesn't. He said she had some knee problems when they hit. It wasn't that hard, but she did fall. She did hurt her knee, and she did stop skiing. So she lost that half-day pass, and oh, man, we're all going to feel bad for Gwyneth Paltrow, who had to waste, however much it cost for a half day of skiing. But missing out on time with her family. She loves skiing because she did it with her dad, who passed early, and her boyfriend, soon-to-be husband, and his kids, same age as Gwyneth's kids, one of their first trips together. So there was some sentimentality there to all of this. He also talks a little bit about the difference between treating doctors and expert doctors, which we've talked about before in other cases, and I've kind of gotten your all's take on that. We'll probably do more of that as those witnesses testify, but let's get to some of the fire here at the end of his opening. And we talk about the objecting, and we talk about whether or not you should or shouldn't object during opening and closing. We always say you only should if it's absolutely necessary. It is kind of, an unwritten rule that you shouldn't do it. You shouldn't break it up too much. But he was doing a lot of arguing. I actually do not think this, you guys may agree with me. So tell me if you guys think that he objected too much, the plaintiff's lawyer, because I don't think he objected too much. I think this lawyer did a lot of arguing, a lot of testifying, talking about a lot of things that were not coming in at this trial. And I would have objected, maybe not as much as this plaintiff's lawyer, but I would have objected a lot to his arguing. Most people thought he objected too much, but that's all just kind of the way that people look at it differently. But let's hear how Gwyneth Paltrow's lawyer felt about being objected to that many times.
Lady Justice. So the blindfold you get, we're not going to feel sorry for him. We're not going to make our decision on that. The weighing of evidence, they have to have more evidence than not. And the sword, we are defending a false allegation, and we need your help. And thank you so much for doing it. I'm done. And
Overrule just a little latitude there.
that's about 10 overruled objections during my closing, which I think is inappropriate, Your Honor.
I believe he meant opening. And these lawyers are getting under each other's skin already. This guy is very sarcastic, kind of, and willing to muck it up. And more defense lawyers are like that than plaintiffs' lawyers, because they kind of want the jury to look at this whole system and be like, ugh, these guys, why are we even here? But the plaintiffs' lawyers want juries to like them, usually. So he was very upset about that. The judge calls him up to sidebar. He's like, 10 overruled objections. I think that's inappropriate, Judge. He was not happy. And Team YouTube, don't say objection. Well, yeah, don't argue in opening statements. I know a lot of lawyers call it opening argument. I would disagree with them. But don't argue during opening statements, and then maybe there will be less objections for argument. All right. And then we get to our first witness, Mr. Ramon. Mr. Sanderson's friend, but not very good friend. He's an expert skier and almost Olympian. They only hung out a few times. Sanderson's also an expert skier. Never seen him collide with anyone all 6 times that he skied with him. And, he usually skis great and stays right with him, and he is such a great skier. He said he only skied with him twice after the accident. It wasn't the same. He totally can't ski anymore. He's like, what am I doing? Why can't I ski right? They talked about doing the pizza and doing the parallel or the wedge or whatever they called it. Rules of the road, ski under control, and never leave an accident if someone is hurt. That's one of his main rules of skiing. Why do you think that is? We're not going to hear the words hit and run. Both sides are dancing around it, though. Terry was not impaired. He was 35 or 40 feet, and he did the old, I'm going to take the tape measure and walk to the back of the courtroom. How far is 35 feet? You can see the accident from that far away. GP slams into Terry very hard, right into the back. But they also talk about how she was going back and forth and Terry was going straight. I don't know. Eric Christian then was screaming. He was very hostile towards Sanderson. He works for Deer Valley, and he had to get in the middle. And he basically said the report from Christensen was full of lies and inaccuracies. Sanderson never said GP appeared in front of him. He thought Terry had a brain injury, but he still went for a couple runs with his friends, I put. It's like, I thought he had a brain injury. He really seemed discombobulated, that he didn't know where he was. He was knocked out for 2 minutes, whatever. And even when they came back after finishing their runs, what the defense lawyer pointed out, I knew that was coming. He said Terry still wasn't coherent. So he still wasn't coherent, but he's posting videos and talking to his daughters and saying, I'm famous. He doesn't know Terry well enough to say what's different after the accident. Yet he skied with him and talked about how it was different that he was skiing. And it's interesting. I'm interested if this guy was considered, I know he was considered a fact witness, but usually the court will limit how many before and after witnesses you had. And my guess is Sanderson argued this guy's not a before and after witness. That's kind of inside baseball you guys probably don't care about. And then I thought it was funny. Plaintiff's counsel asked if he could remove his jacket in the courtroom because it must be warm there. I guess it's like snowing outside, so they probably have the heat cranked inside. And then we get cross-examination, which is kind of the highlight of the day and where most people were posting about. Took a long depo of you a few years ago, didn't we? Did you ever in your depo say Gwyneth Paltrow took out your buddy? Or did Christensen say? And he said no. He gets dyslexic when he gets nervous. It's like, I don't want to make light of or harp on people for saying you get dyslexic when you get nervous. But when you say something like that and you are the key eyewitness and fact witness in the case and you're colorblind and couldn't tell who was wearing what and they almost looked like one person that day, how much credibility and weight are we going to put on this witness? If he's dyslexic, could he have misremembered who hit who and who was uphill versus who was downhill? Just like he misremembered which person Christensen said took out the other person. I think it has to be stated because you have to represent your client zealously. He also said, when Christensen said, your buddy took out Gwyneth Paltrow, and he wrote it in the report, and you heard people saying it that day, you never corrected them once, did you? And this is after you think your friend was knocked out unconscious with a brain injury, right? So let's get to this. I'm famous. My friend watched this discussion that he has with Mr. Ramon. I think it's 5:49. Let me see here. Yeah.
Here's whether Terry Sanderson sent to his daughter something from you.
No. Overruled?
No, sir.
Can you repeat that one more time?
Yes, I'm seeing if you know anything about this document.
No, I don't know anything about any videos.
Here's what happened from my friend, an eyewitness, and then something. You don't know what that is.
No, I have no idea.
Let's look at the top of Defense 102. Now, his daughter responds something to the effect of, I can't believe this is all on GoPro. Do you know what that's referencing?
I have no idea.
You've never seen a GoPro, have you?
I know what a GoPro is.
Oh, I'm sorry. Of this exact case.
I've seen a
Of this
GoPro.
collision.
No.
All right. Let's now go to Defense 87, which is the...
So he has no knowledge of this, but it says my friend and eyewitness, but I thought he was the only eyewitness. Very interesting. So then we continue on with his testimony, and he impeaches him about 8 to 10 minutes versus 4 minutes. How long did Gwyneth Paltrow stay around? It was very clunky. The impeachment and the depo transcripts and showing him and finding where it was miserable, unbearable, so hard to get through. And this guy was trying to disagree with the lawyer, regardless of what the depo said. He was trying to nitpick and say false. I didn't say that. I said it like this. Now, listen, some of it's important. You got to make sure it's said accurately and said appropriately, but he was impeached so many times in changing his testimony on the stand that I really felt like, and I made the comment on Twitter, that this reminds me of a law student who plays a witness in a mock trial. They are the most argumentative witnesses ever. And whenever I coach a team or I judge a competition and I give them some feedback, I say, you're just supposed to be a witness here. Don't argue so much. It makes it harder on them. They got to gain control of you. Fine. You can give them a difficult answer, but don't fight them on everything, because that becomes a witness that people don't like. And that was a lot of the comments I got about Mr. Ramon. But let me know. I also got some good comments. People said he was really great. He stood up to that jerky, condescending lawyer. So people liked him as well. So tell me, on a scale of 1 to 10, how do you feel about Mr. Ramon's testimony? 1 being not effective, didn't believe it at all. 10 being I felt like he was so great, believable, super credible. I believe him. So put in there somewhere between 1 and 10 into the chat, please. EB, I'm going to get to your question. I actually have it starred. All right. They've gone to lunch multiple times together, blah, blah, blah. But here is something I want to show about where they really do not want them to look like they are good friends.
At the time she skied away, about how much time went by there? Read your answer on line.
Don't know.
Start reading the line 6. Reading this?
Yes, I am.
What is it? Line 8 say. Line 8. Are you reading this?
Yes, I am.
What is it? Line?
He's like, are you reading this? Like, come on. And he did that so much today. And EB said, hey, Tragos, I have a question. Can an attorney have a little fun or belittle a witness during cross-examination? So the answer would be no, they cannot belittle a witness by definition. But can they have a little fun, be a little sarcastic, try to make the point that they think this person is lying or being much more difficult on cross than they were on direct? Yes. And can you or I define it as belittling or condescending sometimes? Yes. But you run the risk of the jury hating you.
Line 8 say the 3 words there.
I don't. Okay, it says about 8 minutes.
Thank you. We have a question. Your Honor,
That can take place on redirect.
which has already been ruled on. Okay. Let's start from scratch.
So the 1 to 10 numbers are all over the place, but I would say most of you are saying below a 5 or below. So a failing score for the most part. I saw no 10s.
Sure. Terry was your Facebook buddy, Drew,
He was on Facebook.
and you were friends with him.
Acquaintance.
So on Facebook, friends means friends. You're a friend of his on Facebook, or do we have to
There's
pull
people
that
that
up?
had 1,000 different friends on Facebook. I
So I can understand this lawyer's frustration right here. He's like, you're Facebook friends with the guy, right? He's like, acquaintances. It's like, is that new? I didn't know Facebook had an acquaintance button. Like, it'd be hard for me, who's kind of sarcastic. I try not to be in trial, but it's like, buddy, are you being serious? We are now going to argue what a Facebook friend is? Come on, man. Come on.
that's Facebook.
And you were friends with him.
Acquaintance.
So on Facebook, friends means friends. You're a friend of his on Facebook, or do we have to
There's
pull
people
that
that
up?
had 1,000 different friends on Facebook. I don't even.
He even uses air quotes. He's not trying to trick you. He just means you can see his posts on Facebook.
Do we have to pull it up? We've got it.
Well, you can pull it if you like. I didn't even go on Facebook.
So the way this works is I ask a question,
Okay.
and if you say yes, we go on, and if you say no, then we pull it up.
Okay. Yes. We're on Facebook.
You're friends on Facebook.
Yes.
Somebody said Facebook does have acquaintance. That's something I was not aware of. So then I would have, then if it does, then I would say, okay, are you a friend or are you an acquaintance? Because I'm pretty sure he was a friend, which would just be better for the defense.
You're colorblind. True?
Somewhat,
So
yes.
that was it. So then again, even then, he didn't want to give him that. So this is, I wasn't even planning on playing this, but why not? You're colorblind. True? Somewhat. Why are you qualifying that? We all know you've already said you're colorblind.
You're colorblind. True?
Somewhat, yes.
Well, in your deposition, you didn't say somewhat.
Yes. Sorry.
So one rule of the court.
He's like, no, sorry. That was a lie. Like, sorry. Yes. It's like, that's not good. That's really not good. Don't argue with that. If you said you were colorblind and you are colorblind, just say you're colorblind. That makes it so miserable for the lawyer and for the jury when they have to go back and forth and do this. Talks about how he wasn't in the workforce for 10 years. He does skiing and scuba diving. They also quibbled about that. Oh, well, traveling and skiing and scuba diving. It's like, whatever. They've gone to lunch multiple times. I already said that. Then we hear a little bit about the helmet issue, because it seems like this person said that Paltrow did not have her helmet on, which is a big deal, right? And a safe skier. If they're not wearing their helmet, I think it's a lot more plausible that they don't care about the rules of the road or of the slopes or whatever, and they're not a safe skier. So he impeached him here. And again, it was clunky, but he gets his point across.
Now, when you heard a noise, that's what drew your attention to Terry.
True.
Terry was wearing a helmet. True?
True.
The person he collided with was not wearing a helmet. Is that true? That's your memory?
I don't know.
Did you tell me she was not wearing a helmet?
I'm not sure. I don't remember what she was wearing.
Do you remember previously testifying that you knew she was not wearing a helmet?
I'm not sure what she was wearing. If you look through the
Sir,
deposition,
listen to my
I'm
question.
sorry.
Did you previously tell me under oath that she was not wearing a helmet?
I can't answer that
And why can't you?
because
Why can't you tell me that whether you previously told me that?
that she was not wearing a helmet.
Yeah.
I wasn't really paying attention with what she was wearing.
He's trying to get him to say, did you say she was not wearing a helmet? Fought back and forth. Eventually, he does say yes. keeps impeaching him over and over again with this stuff. And then we get to another one of my favorite lines that I also put on Twitter. If you guys aren't following me on Twitter, get on Twitter at Tragos Law, TRAGOSLAW, Twitter and Instagram. We're trying to get Instagram to 20,000 followers. We're at like 17 or 18,000. So go give me a follow on there. You can see right here. It's little on the screen, but at Tragos Law, if you want to give me a follow, because this was one of my favorite lines of the day.
You weren't looking at Terry until the noise and collision.
True.
Now, Terry's a good skier, he said, and he skis parallel.
True.
And the collision occurred to the far right if you're going downhill for the skier's right. True?
True.
And there's a bit of not a cliff,
I must have started a little early, but we'll get to it. You'll know it when you hear it.
but kind of a sharp descent right there. True?
True.
Gwyneth was skiing with an adult male. Do you remember?
Yes.
And you thought it might be the Coldplay guy. Was that your...
I didn't know who it was.
Did you see the smirk on the lawyer's face? You thought it might be the Coldplay guy. I think that's literally what I said. I was like, I think she was married to the Coldplay guy. I think that's literally what I said on the intro video to this trial. But that's why this celebrity is a part of this case. One of the overarching themes we asked, how much would that be a part of this case? Did he even know it was Gwyneth Paltrow? Well, pretty immediately he found out because of Christensen, and he saw a male next to her, an adult. It's like, oh, is that the Coldplay guy?
Did you tell me in your deposition you thought it was the Coldplay guy?
Joanne, she's into that stuff, and she said.
Did you tell me at your deposition that it was the Coldplay guy?
I said it might have been.
And her son, you saw that her son came over?
True.
So I just thought, yeah, Eden, samesies. I thought that was really something, that it was the Coldplay guy. So then, in continuing with this celebrity and in continuing with the other theme of the hit and run, we get to something I thought was important. If the plaintiff is going to hit on the hit and run and she didn't stick around and blah, 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 and this is the eyewitness and he's totally unbiased, and this guy's arguing with literally everything, he didn't really argue with Paltrow's lawyer too much on this line of questioning here about what did he do when he found out it was Gwyneth Paltrow, and how did she respond based on what he, Mr. Ramon, did?
Your buddy took out Gwyneth Paltrow. True?
True.
And you, on hearing that, actually backed up because you were going to go to get a closer look. Is that true?
True.
And when Gwyneth saw you doing that, she left.
True.
You were trying to talk to her, and she was not responding to you. True?
True.
So he finds out it's Gwyneth Paltrow. He thinks it might be the Coldplay guy. So he backs up on his skis and tries to go towards them and tries to talk to Gwyneth Paltrow. And that is when she leaves and does not want to talk to him. That's pretty important to me. That shows me you guys wanted to be a part of this. You wanted to be famous or whatever. You wanted to talk to her. You want to tell your people later. You met the Coldplay guy. You met Gwyneth Paltrow, which I don't blame you. If Gwyneth Paltrow ran into my friend, I can't say I wouldn't try to go be like, hey, what's up, Gwyneth Paltrow? That's cool. What's up, Coldplay guy? We're being disrespectful to him because I feel like he's more famous than Gwyneth Paltrow. I just can't remember his name. But, like, I would hope my friend wouldn't sue Gwyneth Paltrow if he's the one that ran into her. But, I mean, I don't think that's that unreasonable. I don't know. All right. Then the defense attorney reminds him that the court dismissed the claims against Deer Valley once again. We heard that once again. And then at the very end, he says, there's an inherent risk of getting injured skiing, right? And people could run into you. And he agrees with him. Chris Martin, that's his name. Thank you. Coldplay guy. He's probably played. Oh, people are saying Gwyneth Paltrow is way more famous than Chris Martin. Okay, sorry. I don't know. I thought Coldplay was a pretty big band. All right, sorry. How do we get off on these tangents? So he agreed that there is an inherent risk, and he's Mr. Ski Expert, right? There is an inherent risk skiing. Then redirect was even more about the depot. reading the depo transcripts in to try to rehabilitate him, talking about the 7-hour deposition. Recross was even more talk about the helmet, and that Sanderson said he was okay after a crash. And then I only heard a little bit of Teresa Davidson, the BNA witness and ex-girlfriend, who only had glowing things to say about Terry Sanderson and how when he got home after getting hit, he looked like he got hit by a truck. Now, for scheduling purposes for us, I may miss 30 minutes to an hour at the end of each day. I will watch them the next morning because it's out in Utah on Mountain Time. And that 6 to 8:30 time is really my family time after work before my kids go to bed. So I will not be watching the trial during that time period. I may catch up 15 or 20 minutes before the video starts, but I did not see the entirety of Teresa Davidson. I know you guys are going to all be respectful and cool with that, and you're all so nice when you said that. When I said I was going to have to miss some of it, and you guys are always so nice with that. But so I may miss a little bit at the end of each day, but have no fear. We will talk about this last hour and what Teresa Davidson said on tomorrow's live. So let's now take a moment and get to your questions. If you guys haven't hit that like button yet, almost 6,000 people, that's pretty good for day one of a trial, right? Especially a trial that's not really blowing up, but it's an injury case, which is really interesting to me. And we're getting into causation. We're getting into pre-existing conditions. We're going to get into all that. We're going to get into a lot of medical testimony, which I want to talk about with you guys. You may think it's boring, but I will give you insight onto what these lawyers are looking for, what they're trying to prove, why they're asking certain questions. And you can give me insight into what juries think when this testimony is happening. We're going to have some by deposition, which we always worry about by depo or by video. How boring is it? Are you falling asleep? Are you even paying attention? Think about that as you're watching this case, because I'm going to want to know. But today was mostly on what happened and how did it affect him. Deborah B asked, so sorry, hit the subscribe button, hit the like button, hit the reminder bell, become part of the crew, the chat, potential jurors that I talk to about this stuff. It's so much fun. And I love this chat. I love this crew and this community. Deborah B, what did you think of Gwyneth Paltrow's demeanor? I didn't notice much of it, if I'm being honest. John O'Reilly, is what we saw today an accurate representation of the current state of the PI bar? I hope not. Here's what I'll tell you. Here's what I'll say about the PI bar. There are some really, really amazing lawyers. And there are some really, really horrible, horrible lawyers on both sides, on the plaintiff side and the defense side. We did hear that this is not the original lawyer that took Terry Sanderson's case. So was he struggling to find somebody? Who the heck knows? But I will say this would not be a representation of very, very strong personal injury trial lawyers. They would be much more engaging, much more charismatic. I would think much less, crotchety feeling. I felt like they were getting into the mud a little bit with the defense attorneys. So this is not what I would expect from really, really good PI lawyers personally. Not to say they're bad lawyers. They look very experienced and they could be very good. Ashley, when Gwyneth Paltrow's lawyer said, I don't want an objection, I spit my drink out, the audacity, I was dying too. It was so funny. It was so funny. I mean, that guy's funny. Mehdi, I don't get why it took so long to file. It doesn't take that long for a civil suit, even in Salt Lake City. This guy is so sus. I've been on that slope a billion times and can't picture that collision. Interesting. I did have a picture of the collision, but I don't have time to put it up. We're already over an hour. So there are a lot of reasons for delay. I do think if my case was 7 years old, I would feel like I would have to explain that to a jury. And I think if you got a good explanation, you may understand. If they don't have a good explanation, then maybe your thoughts are the sus is real. Abby, I was in a ski accident, woke up on a stretcher behind a snowmobile. Snowboarder accidentally cut across my ski. Accidents happen constantly. It's an at-risk sport. Wonder if at-risk waivers are signed. I think they are. But again, that wouldn't include Gwyneth Paltrow. That wouldn't include the person that was negligent in hitting you. That would include Deer Valley. I was also in a ski accident, just me by myself. I was a kid. We were all going one way. I made a wrong turn. I was so little, I didn't even have poles. And I went down like a whatever black diamond with all these moguls. And I was like, bum, 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 bum. And I hit. I don't remember anything. I woke up and I stood up and the snow was all red. And I was like, oh my gosh. And I was bleeding, but it was just a bloody nose. And I was put in one of those like sacks like this. And I was like tied up and the ski patrol skied me down the rest of the mountain. It was kind of crazy. Tiffany, my entire adult career has been ER. A lot of people don't understand what urgent care versus emergency care really is and frequently go to the wrong place. I agree with you. But does your average juror know? And do you explain that to them as the lawyer? That's all part of it. That's all part of being a trial lawyer. It's a BS tactic play. I think that was when we were talking about him not being in the room. Cat C, thank you for the super sticker. Mandy, these lawyers that did the opening statements are what you get when you order them from Wish. I don't know what Wish is. Rape victims have to sit and listen. DV victims have to sit and listen. So he should have to sit and listen. They don't always have to the whole trial, but I get what you're saying, to parts of it. Medi, I tripped over something, tumbled, and rolled down that hill, bit through my lip, broke a leg, had a concussion, not as severe as his story, and was life flighted to the ER. Deer Valley takes injury so seriously, he's a liar. So somebody like you, and this is the other thing, on this jury, we could have people with your experience that are avid skiers that have been to Deer Valley a million times. Pretty interesting, I think. Pretty interesting, because sounds like you could be on that jury. John, what was the issue with Sanderson's attorney misreading the accident report? Did you catch that, Peter, and the chat? He misread a part of it and then he reread it. I think it was not done intentionally. There was a couple times where that happens, and that happens in every trial. There's a lot going on. Netwoman, every time the lawyer for GP would win an objection, he would say thank you, just like Boot. Yeah, he seems like he's going to say thank you. He seems like that kind of lawyer. The Tomlet, TBI survivor here. You lose everything when you go through a severe TBI, including friends and family. No doctor warns you. It's poorly understood. And it's very difficult to find good treatment for, because we have clients that have that. It's very, very difficult. Boomer, Peter, friend said on direct that the first person to arrive was an employee wearing a green jacket. Later, he testifies to being colorblind on cross. That's a great point. I didn't even think about that it was a green Deer Valley jacket. It's a great point. Brandon, your thought on AI's impact on the legal industry. So you're not allowed to use it to write a lot of things. I think it can make our lives easier with certain things, but a lot of lawyers like myself are just too scared to use it. I don't want to give it confidential information. I don't know what's going to do with that confidential information. You can't talk to it and deal with this. It's just different. And lawyers don't like change usually. I don't know. I don't know the answer to this question. Lauren, Peter, do you ski? Of course, ski instructor. And do you know what you just hit? He's in defense mode immediately. Deer Valley, 100% taking care of their own. Sure, I would not say I ski. I've skied like 3 times in my whole life. I'm from Florida. I live in Florida still. So I would not be like a ski expert or know all the ins and outs about this. Leslie P., I cannot wait for the dueling neurologist. Absolutely. Yes, 2-minute needs to be taken seriously, but neuro is tough. Always difficult to pin down. I agree with you. Causation is tough. How you prove when the injury occurred. Now, broken ribs, usually traumatic, and they only started hurting right that day. But cognitive stuff can be difficult. Bryce Jones, and they're always going to blame it on, defense is always going to blame it on comorbidities, on aging, on pre-existing, no matter what. It doesn't matter how good or bad your medical history is. They're always going to blame it on that. That's what they do. Bryce Jones, I'm from Utah and snowboard at Park City all the time. Park City was the first place I ever went skiing. That's pretty cool, right? This guy sounds like he is fabricating. The collision probably wasn't as bad as it may look, which is why the collision is not as bad as it may look, which is why she probably didn't give it merit. Tina, I like seeing all the different attorney styles. If they were all the same, how boring. I agree. And every attorney is very different. JB, this screams lies and untruths. I found the prosecution witness the worst liar on cross. Jesse Sue, could they still settle even after the trial has started? Don't forget to hit the like button. Like this video. Yes, please like this video. Yes, they can settle at any time. They can settle. We just settled the case after we got a verdict. Many cases settle just like Johnny Depp's case. That's settled for $1 million after they had a verdict for much more than that. Civil cases, you can settle anytime. Sue, if Sanderson is an expert skier, why is he on the bunny run? Sus. So I don't think we got that answer, but I think we will get it. It may seem like maybe they did talk about it. Gosh, I can't remember. I know that was a question a lot of you had yesterday. If you guys heard this answer while watching today, put it in the chat. D-Rock, can the plaintiff still make a few dollars from this even if he does not win? If he settles, yes. But if he loses, no. Lauren, my biggest hang-up is why would GP go this far if she knows she's at fault? But have you seen people take a lawsuit to trial just because they can afford to? Absolutely. I've seen a lot of people fight the whole way too because they don't agree with the damages. So even if they agree with that they're at fault, but they don't want to pay you $3 million or whatever, they'll still fight it as if they weren't at fault. So absolutely, people take cases the full way, even if they know they did it. Debbie O, I gave the witness a 2. It would have been a 1, but I've had the garlic cheeseburger at Cotton Bottom, and they're as good as he said, so plus 1 point. You guys are hilarious, I swear. Like, this is good. This is why I say this stuff is fun. Like, again, difficult situation. If a guy's got a brain injury, that's the allegation. Difficult. We're going to talk through it. We're going to listen to the medical testimony. We're going to go through all this, but I just love you guys. This is awesome. And give me some real local knowledge there on the garlic cheeseburger. It did sound pretty good. I'm not going to lie. Simply Cheryl, welcome to the crew. And Nikki Lewis, some new members. We're getting ready. It's already almost April, which is going to be our next members only video. Nicole Mobley. So is all this on the GoPro or we don't know yet? The GoPro video and that link does not exist. The lawyers never saw it. It's never been produced. And because the plaintiff never produced it and it's clear he had it at some point, it seems like the defense is going to be able to argue a negative inference like, wouldn't it be nice if we saw what was on that GoPro? Then we wouldn't have this he said, she said argument. Heather A. and Ivory Bell, welcome. Medi, are they forcing Gwyneth to be present at these hearings or is her attorney's presence enough? I'm going to have to call the PC courthouse and ask if I can attend one of these hearings. You should attend. It's the trial at this point. You should see if you can attend. It seems like if Sanderson doesn't have to be there for the whole trial, I don't know how they could force Gwyneth Paltrow to have to be there the whole trial. It seems like maybe she wants to because her lawyers have told her that would look good in front of the jury, or she's taking this very seriously and wants to be there. But we've had defendants asked to not be at trial. We've objected sometimes. So it depends on the case. Sometimes we've let them not be there at trial because sometimes, again, we think that it looks bad in front of the jury, like you don't even care if you don't sit there during the trial. So it's a case-by-case basis. Thank you, Vicky K, for the super sticker. Faith in the unseen. Does it take this long to get to trial because it's GP? That could have been a factor. But if it is, I think the plaintiff's lawyers would argue that more than the defense lawyers bringing up how long it took. Katie, I struggle hard with the work-life balance. Mad respect to you for honoring that time every night. I do too, Katie. But I actually think like having this and talking to you guys about it and getting the message and stuff helps remind me of that. Because I really like to see stuff grow and to see stuff become something bigger and become something more interesting and to get more thought, whether it's work, whether it's this, whether it's discussions, trials, whatever it may be. So it's hard for me to turn that off. You know, it's hard for me to not chase success and growth and things like that. So I appreciate that. And we all need to work on it and focus on it. Azam. Hi, I'm with my students now. They say hello to the Lawyer You Know crew. What's up, Azam and Azam's students? We're here learning too. Greg Hall, Wish is the internet's dollar store. Cheap crap. Ouch. Ouch. Heidi, I wish I was part of that jury, but the way it works here, I think I can only serve as a juror in Salt Lake City where I live. Usually that's correct. I could be wrong, but that's what I've been told in the past. That would be pretty common. Colleen, why weren't the email addresses and names redacted? Just curious. If nobody redacts them and nobody asks for them to be redacted, they're not going to get redacted, especially in civil cases. A lot of times that's up to the lawyers. Counselor Kia, welcome. Glad to have a counselor in the membership. Heidi, thanks for explaining everything, Peter. Also, please let Pete know we would love to see more videos from him. I know the last one was ruined. Yes, that's miserable, but we are going to have multiple videos from Pete. There is a new class action lawsuit issue with eye drops that Pete's going to be doing a video explaining that on. And Aiden Fucci's sentencing stuff is happening right now, and he is going to do a video this week. We have had a crazy week. I don't know if anybody's heard about the tort reform here in Florida, but it has created a very crazy week at the office for us working. We were at the office literally for hours and hours and hours and hours and hours over the last few days. Termina Lance. This guy is service connected with the VA, so most likely all of his medical bills are 100% covered. Here for the truth. I cracked my skull seeing when helmets were not a thing. Didn't realize it for 5 years. Just thought it was my migraines. Ouch. Ouch. And I also saw somebody say, how can you get a concussion when you're wearing a helmet? You absolutely can. Nettie's all in the chat tonight. Welcome from Utah. We're glad to have a semi-local there. Let us know if you do get into the courtroom. Welcome to the membership crew. Thanks for being here. This is cool. John O'Rourke, Azam and students are in the house. Hi, friends. So usually we like to try to keep these to an hour, but many times we go a little overtime. And today we did that for about an hour and 20 minutes. But we're back at it, folks. 8:45, hanging out together for the next 8 days, talking Gwyneth Paltrow, talking an injury case, an injury trial. We're going to have medical records and medical bills to go through. What is sus, TMs? It's suspect. Like, it's a little fishy, maybe a little sketchy. I think that's where we're going with sus. Welcome, D. Williams 777. All right. So we're done for tonight. But follow me on Twitter. Rebel Duck, thank you for the super sticker. Follow me on Twitter because I'm tweeting as I'm watching on 2x speed. Sometimes I'm a little bit behind at Tragos Law, and on Instagram. We're posting some stuff on Instagram as well. So get in the action there. But of course, every night, join us right here on YouTube. Hit that reminder bell, hit that subscribe, hit the like button on the way out. You guys are the best. Thanks for being with me tonight. Until tomorrow, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.